Hey everybody, this is Jess Birken, nonprofit attorney in Minnesota. I am here to talk about nonprofit structure and governance for y'all today. I am going to kind of assume that if you're watching this, you are a lawyer. If you're not, that's fine. But just know that I'm going to be using some jargon and some vocabulary that probably lawyers will understand. But I will try and demystify any of those things as we go along. All right, so this is me. I grew up basically working for nonprofits. After I earned my law degree, I also went back to school for a master's in nonprofit management. I actually didn't think I would ever be a lawyer at that point, and I started working inside a mid sized national nonprofit where I did a lot of grant compliance and real estate transactions, and eventually ended up leaving for private practice, where I now work with all types of nonprofits, usually smaller, growing organizations, the kind that often rely on their lawyer board member or their friend to help them out. And I try to give them services that they can access so they have access to an actual expert and aren't leaning on folks like you who are well meaning volunteers. Okay, so what are we not going to do today? I am not going to be reading the statute to you today or citing case law. Everyone that is watching this is a grown up. You can read. If you're a lawyer, you can do the research. What I'm going to do is talk about sort of nonprofit 101 issues, things that I look for that are going to influence the organization and all of its problems that it has in a big way. I'm going to walk you through how I approach things as an expert in nonprofit law or as a specialist in nonprofit law, whatever those are words that we're not supposed to say unless we have some credential, but you know what I'm saying. If we have time, we can also work through a few problems. All right, so are nonprofits really different from other businesses? I mean, like, really, at the end of the day, are they really so different? No. They are, pretty similar to other businesses. They are different, but they are similar. And I know that that's confusing, but I've just heard so many times from especially the smallest nonprofits will say something like, but we're just a nonprofit. But we're just a nonprofit. We don't have to follow the law around employment, wage, and hour, as if the regular rules and regulations for businesses don't apply to them. And here's the thing, pretty much everything that is true for operating a business is also true for operating a nonprofit. Okay, on the taxable entity side, we have taxable entity business legal issues. And on the nonprofit legal side, we have nonprofit entity legal issues. So we both have corporate registration compliance. We both have to follow employment law. We both are affected by contract law. We both have rules around data privacy, data security, GDPR, California, blah, 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 blah. We both have tax compliance, only on the nonprofit side, it's worse because we have special rules that apply to us. We both can go through mergers and acquisitions. It looks a little different on the nonprofit side, but it's a thing. On the business side, we can go out of business. We could go through bankruptcy. On the nonprofit side, we dissolve and our assets transfer to another nonprofit. In a taxable entity where there's shareholders, you might have a lawsuit brought up by the shareholders. In a voting member organization, you could have a litigation started by the voting members. We have, on the business side, we have investor issues, right? On the nonprofit side, we have funder issues, fundraising compliance issues. And both of us are required to follow GAAP accounting, and nonprofits have to follow nonprofit accounting on top of that. So, Nonprofits and taxable businesses are really very similar, and yet nonprofits are totally different. So, whenever you're dealing with a nonprofit, you have to put on a different set of glasses. You have to use a nonprofit lens. And think of this as like a pair of glasses that you need to keep on at all times, because as you look at this business through these glasses, you will see that many times the answer to an operational or a legal question is different because it's a nonprofit. And nonprofits are so highly regulated. My friend, who is a finance and accounting consultant for nonprofits, Megan Tarnow, she and I like to say nonprofits have more in common with a Fortune 500 company than a lemonade stand. That is the level of regulatory environment that nonprofits are in, and it doesn't matter if they're $1 million organization or a $50 organization. At its core, nonprofits are a business, but it is surrounded by this layer that sometimes protects the entity and many times creates more rules than your regular business would have to follow. So, this nonprofit lens is a lens that you have to keep looking through all the time. Look at the, list that we just talked about. What is the first core of any business operation? The corporation itself, the corporate body. So, what form that corporation takes and how it's governed is really critical to your business entity, to your nonprofit entity. So, I'm going to spend some time on that today because it is so important and it affects so much of how the organization works. All right, so if you're watching this and you're a lawyer, you understand why we have corporations. Corporations exist to provide limitations on liability to the people inside the corporation. The corporation is like a shield or a protective bubble around the human beings and their bank accounts that are running the entity. Unlike corporations or LLCs or whatever that have owners and shareholders, a nonprofit is not owned by any person. Nonprofits are instead considered an asset of the community, an asset of the constituents that they serve. So they aren't formed or governed like a typical taxable entity. In my home state, in Minnesota, nonprofit corporations are formed under Minnesota Statute 317A. And that could include churches, but it's good to know that sometimes churches are formed under another statute. And in Minnesota, that's Chapter 315, which applies only to religious organizations. But churches can also be formed under our nonprofit corporate statute 317A. So if you're ever dealing with a Minnesota nonprofit, you need to check which statute applies, especially if you're dealing with a church. That's just a little pro tip. One more tip: nonprofits generally are not LLCs. Occasionally, I will have a new nonprofit founder sort of like wander into the office and say that they formed a nonprofit LLC. Usually they did not. They just formed a regular limited liability company and want to say that it's a nonprofit. And in Minnesota, nonprofit LLCs have special rules that apply to them. And they're mostly utilized for like giant nonprofits to collaborate in some shared venture where like multiple big nonprofits are members of the LLC, or it's used to form like a subsidiary to limit liability in a single member LLC where the tax exempt status of the single member nonprofit flows through because the LLC as a subsidiary is a disregarded entity. For our purposes today, we are keeping this at a 101 class. So if your eyes were just rolling back in your head, it's okay. I'm not going to talk about that anymore. This is a 101 class, so please just assume we are talking about a nonprofit corporation And we are in the state of Minnesota, and it's a 317A nonprofit corporation. All right, so as I mentioned, the corporation is like a bubble or a protective shell or a shield around the people that gives you protection from liability. So, who in a business, the corporate shell or the shield is protecting the owners, but who is being protected in the nonprofit corporation? The board of directors and the officers who are selected from that pool of board members. On the outside of the corporate shell, we have the public, we have our donors, our funders, people who are making grants to us, our members. Those people are on the outside. Now, we might have a voting member organization, and now our members come inside the corporate shell. Okay, so now we have this pool of people who have legal rights that are called voting members, and then we have our board, and then we have our officers. So this is just important to understand, like, what is the sort of principal formation of the nonprofit corporation. Now, to make it slightly more complicated, let's go back. If I can, oh, I can't go back. Okay, so we have the bubble. What happens when we want to add a branch office or like an affiliate? That's called an affiliate model. Now, I'm going to slice the bologna pretty fine here, but let's just, we'll use the Red Cross as an example. You have national headquarters of the Red Cross USA. That is an incorporated entity. But then you have regional affiliates. These are also those smaller circles. You have your Minnesota Red Cross, your Wisconsin Red Cross, your Pennsylvania Red Cross. They're each incorporated and they are a regional affiliate of the national organization. So, from a corporate perspective, what does that mean? That means they're their own entity and they are connected to the headquarters, to the national organization with a contract. That contract is usually called a charter agreement or sometimes it's called an affiliate agreement. But you have a bunch of corporations who are connected through contractual relationships to sort of like the mothership. Now, sometimes we have organizations that have a chapter model. This is different. Now, sometimes people will use the word chapter and affiliate interchangeably. I distinguish them because an affiliated corporation is its own entity, and strictly speaking, a chapter is generally going to be unincorporated. So this is where you're seeing in the diagram here, the bubbles are now inside headquarters because they are not separately incorporated. We have a chapter model. That means we're all under one umbrella. The example that I like to use for this is my old employer, Pheasants Forever. Pheasants Forever, maybe you've heard of Ducks Unlimited. These are organizations that have little pods of volunteers who are out working on mission delivery and doing stuff in their local community, but they're not separately incorporated and they do not have a contractual relationship with headquarters. They are literally little groups of volunteers, and usually there's some kind of member, whether it's voting or non voting, but there's some kind of volunteers that are maybe sprinkled all over a state or sprinkled all around the country, but legally they don't have their own entity. They are technically all one organization, and just within the organization, they have like created an organizational structure internally to say, oh, you are the Ramsey County chapter, and you are the Dane County chapter, and you are the, youth chapter, but you're all technically one organization. So that's just good for you to know that that exists. And these are different things. And that plays out in different ways when you have problems, right? So a separately incorporated affiliate entity, it could own property. It could enter into contracts. It could hire its own staff. It can have its own income tax exemption. It could have its own sales tax ID number. This chapter model, these are just volunteers. We're in one organization. We have one headquarter. We have one tax ID number. We are not hiring people. We are not supposed to be entering into contracts. We are not supposed to be getting our own tax ID numbers. You will see if you work in this space long enough that that affiliate model has pros and cons, right? You are separately incorporated. You can kind of do what you want. You have a contractual relationship with the headquarters, but like other than that, as long as you're complying with that, you can kind of do what you want. That comes with some costs though, because you're separately incorporated. You're going to do your own books. You're going to do your own taxes. You're going to pay your own payroll tax. It's expensive to have your own business. On this side, the chapter side, we are going to have a lot less freedom. Those chapters are just volunteers. Even if they call themselves president and treasurer, they're not really officers of anything. They're just volunteers. Headquarters is liable for everything they do. They don't get to hire somebody. They don't get to fire somebody. They don't get to enter into contracts. They don't get to own real property because they are part of headquarters. And if they want to headquarters to buy some property, they need to run it up the chain. So this is important because if you're working with an organization, you're volunteering, you're whatever, you really need to understand which model you are working with because especially if you're volunteering on a board, you do not want to give bad advice to your colleagues. If you really are just a bunch of volunteers and you have no legal authority to do stuff, you need to be careful about what you are saying you guys can do. Okay, so if that is clear, I'm going to make it even more complicated. You can also have a model where the nonprofit headquarters, let's say, um, now we'll use the Girl Scouts as an example. You can have an affiliate model with chapters in the affiliates. So you can have a National Girl Scouts USA, right? That's the national organization. They are a nonprofit entity. They are their own corporation. And then you have where I live, it's the Wisconsin, Minnesota River Valley branch of the Girl Scouts of America. And then under that affiliate are all of the little Girl Scout troops, which are not separately incorporated, just little clusters of volunteers that the regional entity is responsible for. So you can see how this starts to layer on top of itself and it can get pretty complicated. This is an extremely complicated structure, something that you would think of like a Fortune 500 company that has like, you know, Google now has Alphabet and then they have all of these subsidiaries and relationships and complexities. This is the level to which this nonprofit Girl Scouts USA and all the regional affiliates and then all of the troops, like they have to manage all of the finances and all of the accounts and all the relationships between all these entities and non-entities. And it gets really complicated, right? Um, so just from thinking about it purely as a legal structure, this is where you just really want to understand what is the corporate structure of the organization that you're dealing with and what are the rights between the corporations if you have connected corporate structure. All right. Your affiliate model can also flow down as there is a global headquarters, and then maybe there is a regional affiliate for the United States, and there's an affiliate in the United Kingdom, and there's an affiliate in Canada, and then there are sub affiliates below that who are also separately incorporated. This is also possible. And you can kind of see this I've seen this with like USA Hockey, um, the Academy of Family Physicians. Some trade associations will be structured like this, where there is one global organization, and then there's like a state level affiliate, and then there are sub regional National Association of Realtors. These kinds of trade associations often have very complicated affiliate structures where you have to agree to follow the charter of your regional affiliate, but also of your national or global affiliate. And as you can kind of guess, that makes writing your bylaws more complicated because you have all these terms of all these affiliate agreements flowing down into your organization. All right, so now knowing that's as complicated as it can get, let's go back down to the basic and just think about the corporation itself. In a nonprofit corporation, at least in Minnesota, we form the corporation through the articles of incorporation. In other states, it might be called non-stock corporation formation document, or like other states will have other ways of phrasing this, but I'm just going to say the articles of incorporation. That's what we do here in my home state, and that's the easiest one to say because some of them are a mouthful. So nonprofit corporations need to keep up their corporate filings with the Secretary of State or the Department of Financial Institutions or whatever the entity is in your state. Just like any other business, you must keep your corporate record current with the state, or the state will release your name for use by another organization, involuntarily dissolve you, etc. Okay, nonprofits also can register a doing business as an assumed name. Just like any other taxable entity, they have the right to do that. Um, the thing that I want to just kind of call out is a lot of times I will talk to folks who think that the nonprofit was dissolved because their corporate registration lapsed. That actually is not the way it works. If you are a business attorney, you know that in order for a business to go under, there's a statutory process that has to be followed. The same thing applies to a nonprofit corporation. We have a statutory process that defines dissolution. And actually, when you are apply for income tax exemption from the IRS, one of the things they ask you is what is your process for dissolution and what state rules are you following? So it's important that if a nonprofit is going to go out of business, that it actually follows the process that's defined by statute. In Minnesota, that's 317A.701 to 791. That basically lays out all of the process for how a nonprofit goes out of business. And another thing that you might want to know is that just like any other company, you can order the articles of incorporation. You can get a certified copy, you can get a business copy for like $15 from the Secretary of State's office. So whenever you're about to work with a nonprofit, whether that's you being on the board of directors or you providing some advice to a nonprofit, it's really important to look through their articles of incorporation and their core governing document, like their bylaws, or sometimes they'll call it a constitution, because these are the things that dictate what is supposed to happen in the organization. And I feel like, especially if you're kind of getting involved with a very small nonprofit, the there's sort of like the equivalent on the business side is like the person who has a business but they don't really like pay attention to their organizing documents. So like yeah, technically they have some, but like who knows what they say, and does it really matter because they don't have meetings and don't do things the right way. For nonprofits, you really do need to pay attention because there are IRS requirements, there are rules and regulations, there are things that they must do or must not do. So you always, before you join a board or before you give some advice, you first want to look at the articles. So you can just go ahead and order them from the state. And if the corporate registration has lapsed, you can renew it. It costs $0 and you can do it online. In my state in Minnesota, it's super easy. Just reinstate them and then you can order a copy of the articles. So you should always, always review the articles. And I just want to cover a quick checklist of things that you should be looking for in that document. So first of all, what law are they formed under? What state? Like what you may find that you are dealing with a nonprofit that is operating in your state, but somehow the original founder was like from Vermont and registered it as a foreign entity. So now you need to be looking at Vermont nonprofit law because technically this organization is a Vermont organization. Because remember, the articles are like your Declaration of Independence, or they're like your birth certificate. They just say like this is where I was born, this is why I exist. And you can't change your birth certificate just like you can't change your articles. If you were born a Vermont corporation, you are always going to be a Vermont corporation, even if you register to do business somewhere else. So that's number one. What law are we even dealing with? And then number two, does the organization have voting members? I cannot tell you how many times I have talked to an organization who either created voting member stuff for themselves when they didn't need to, or forgot that they have voting members listed in their articles and stopped using that, and kind of like got rid of their voting members, or like their voting members have sort of like disappeared somehow over the years. And all that's left is the board. So it's really important to know if they're voting members, because voting members under nonprofit law in Minnesota and in many other states, they have legal rights and they have to vote to approve certain things, depending on what the law says, depending on what your documents say. Okay, so that's number two. Number three, how's like the documents like health? Like, like when you open this PDF, is it like a DIY? Is it a scan of a document from like the 70s and it's all like typewriter stuff? Like, is this even something that's been touched in the last 10, 15 years? Is it like the free form from the state and like somebody hand scribbled on there? So, like, what quality of document are you working with, right? And then number four, do the articles allow for written action by the board? Many states, including Minnesota, require if you are going to vote on stuff remotely, if you're going to like take a vote over email or text or survey monkey or a Google form, your articles of incorporation need to allow for that. Otherwise, it's technically not allowed under the law. You must opt in to that provision in your articles document. So that's number four. Because if we're voting by email and we haven't authorized this, then we should update our articles. So number five on my checklist is, do the articles include the necessary IRS provisions? I'm not going to get into what they all are, but just like broadly, do we have the correct prohibitions on like lobbying, no substantial part? Do we have the prohibition on private endowment, private benefit? Do we have an exempt purpose statement besides just saying we're a 501c3? Do we mention that we have a conflicts of interest policy? Like, have we updated this document, and does it actually meet the standards that we would need if we were applying for income tax exemption today? Okay, number six, is the exempt purpose statement specific and is it still accurate? So so many times I will look at an organizing document for a nonprofit and all it says is, we are 501c3, charitable, educational, scientific, religious 501c3. It's like, okay, what did you tell the IRS that you do so that they gave you income tax exemption? Because you had to tell them something, and we have no idea. um, or it might say we do X, Y, and Z. And if you ask them, do you do X, Y, and Z today? They might say, oh, well, no, not really. I mean, we kind of still do X, but it looks totally different. And like Y and Z, no, we haven't done that since like 1986. So those are things that you want to know because it's time to update the articles if it's not specific and if it's not still accurate. Okay, checklist item number 7. Do the articles provide for indemnification of the directors and officers? The articles document should state that the nonprofit will indemnify its directors and officers. In my state in Minnesota, there is a statutory provision that protects volunteers, including boards of directors, but you can opt into this language through your articles and it should be there affirmatively, so there's no question. Number 8, do the articles provide for dissolution that is non-standard? And what I mean by that is like when you read the provision about dissolution, how we're going to go out of business. Is there something weird in there that's not just like we're following the statute? Is there something in there that says like we are a church under the blah 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 affiliates, Assemblies of God, and all of our stuff will go to this specific entity? Or does it say something in there that's not just like a successor in interest with the same or similar mission? That's just something for you to clock because it's important information to know because it may clue you into things like, oh, we're actually an affiliate of another regional whatever. So it's just a good thing for you to pay attention to, even if there's nothing to be done about it. And then number 9, what type of 501c status does the org claim in their articles? Because they will say we are a 501c blank. We're a 501c3. We're a 501c4. We're a 501c6. And I say, what do they claim? Because just because they say that they have that doesn't mean that they ever applied or got it. Doesn't mean that it's not lapsed. So never assume that just because it says so in the articles that that is true. So you just want to know, what do they claim that they have, and then verify, is that correct? You can check with the IRS. There are public databases you can log into for free and double check their status. Okay, so let's talk about governance. Here we're back to the corporate structure. We looked at this screen before, but what we want to say now is, yes, this is the corporation, but how do we run it, right? So from this view, we have the whole corporation, and let's just pretend there's no members, and we have a board. We have a board of directors. The board of directors is the body that makes decisions for the organization. Within that group, there are other people, well, not other people, there are people selected from that group of directors who get additional duties. They have a special extra burden to do something extra besides just be a director on the board and show up to meetings. Those people are our officers. So that's your president, your treasurer, your secretary. So let's look at this in another way, in another sort of like org chart view. So this is our sort of more traditional organizational chart. And when you think of a company, you think you have CEO and maybe some vice presidents and whatever. Here at the top of our organization, we have a board of directors. Many larger corporations also have a board of directors. So, and then below the board of directors is the CEO, or in the nonprofit space, we usually call this person the executive director. Sometimes they do call them a CEO. But basically, the flow down of authority is the board is the ultimate authority. And then they delegate some of their um, role to an executive director or CEO, who then goes on and carries out the wishes of the board. So the board at the very top is setting the mission, vision, doing strategic planning, setting goals, and then they're turning to the executive director and they're saying, hey, we're very busy. We can't get all this done by ourselves. We would like to hire you to go execute on the strategic plan. We would like to hire you, executive director, to go execute on mission delivery. Could you do that? Here's some money. So then the executive director has the delegated authority from the board of directors, and they can turn around and go hire people to help them carry out the board's instructions. So the executive director is supervised by the board of directors, but the staff are not supervised by the board of directors. Staff are supervised by the executive director. And although the board has like the highest level of rights and obligations, anything that really gets done at the organization once you have staff is done by someone else, and it's effectively delegated to that person. So what can the board actually do? Well, they can do everything, but eventually you get tired and you have enough money that you can hire someone. So they get to do everything and they have the right and the obligation to do everything unless they delegate. And then they basically are governing from the highest level, and they are appointing and removing board officers and the board of directors themselves, and overseeing the affairs and the activities of the corporation, and setting policy and procedure, and getting reports on the day-to-day operations from the executive director. The board also has the exclusive right to enter into all contracts, leases, any other agreements. So to the extent that a staff person, including the executive director, can sign contracts or leases, it's only because the board has delegated that authority to the executive director. The board has the right to acquire or manage property, to take out loans or like leverage or put liens on or dispose of their real estate. To the extent that they allow a staff person to do that, that is a delegation of their authority. So the board also has the right and the duty to oversee all the financial transactions, loans, debts, investments, any financial agreements, like anything, mortgages, whatever. To the extent that staff are allowed to manage any of that, it's because the board has delegated that authority. So I hope this is making sense, that ultimately, like, the board is responsible and they are simply delegating their authority to be more effective, just like any business. Like, you, at some point, you just have to hire staff because you can't do it all. The board really only has the right to do things that are in the best interests of the nonprofit. They do not have the right to violate state law or federal law, or to do things that are not in the best interest of the nonprofit. They're not owners. They don't get any money. They shouldn't be paid. They shouldn't have any vested legal rights in any property of the nonprofit, right? So the flow down is they delegate their authority to the executive director, who then acts as their administrative agent. And the executive director, I'm just going to say this again for the people in the back, the executive director has no original power or authority apart from that which is delegated to them by the board of directors. And the board is responsible for supervising, monitoring, being responsible for the actions of the executive director. I frequently am hired to fix a problem, which was basically the result of the board being like, well, we have an executive director and they were doing everything and we don't know what happened. Like, no, that's not acceptable. You ultimately are the legally responsible party. You have to supervise that person. You have to like have some sort of checks and balances. You've got to make sure you know what's going on at the organization. You can't just be like, well, our executive director and the finance person like stole $100,000 and I guess that's not our fault because we didn't know what was happening. Like, no, it was your duty to pay attention. Um, so this org chart is very simplistic, and I just want to acknowledge like this is going to look different at different organizations, like a little teeny tiny dog rescue versus like a giant orchestra or like art center is going to have a completely different org chart. Um, and this is also like a very big organization for some small nonprofit that doesn't even have like one staff person. So if you are working with or volunteering with an organization that has no org chart, just know that it is entirely reasonable that you are going to be asked to do the things that all of these frontline staff, program manager, and executive director people would be doing. Because when an organization has no org chart and it's just the board, you are a working board. And so that is a good thing to know if you're going to join a board and it has no team. You are the team. You will be the one rolling up your sleeves and going out and doing the things. So just bear in mind that that's normal. And if that's not something you're interested in and you prefer to like think about things at a 30,000-foot level and just show up at meetings and review financials and maybe give some money or help them get some money, you're looking to join a governing board. And that is the board that we're seeing here on the screen. It's a board that is governing because it's delegated a lot of its authority to staff. So that's just worth, I think, saying. All right, so you heard me talk about this delegation of authority and that the board has the right to do this and the obligation to do that. And what does that really mean? Well, it means that the board has what are called fiduciary duties. And there are three primary fiduciary duties: the duty of care, the duty of loyalty, and the duty of obedience. So let's just tackle those one at a time. So, the duty of care, what does that mean? It means you have to care. You have to be responsible. Board members have a responsibility to be active and to show up and to do things, to be present in your role in the nonprofit corporation's affairs. Like, show up and do your job. Just being a rubber stamp or like never showing up or never reading the documents provided to you, that is not doing your job. Board members uphold their duty of care when they are prepared, when they show up for meetings, when they ask questions, when they've read the agenda and they've read the handouts that were sent out ideally a week before your meeting. Um, you exercise your duty of care when you're following best business practices, right? So then we have number two was that duty of loyalty. Board members have a duty of loyalty. Like, you can't be half loyal to the nonprofit. You have to have complete, undivided loyalty to the nonprofit corporation. To put it simply, you have to put the interests of the nonprofit corporation above your own or your family's or your friends' interests. That means you don't abuse your position. You don't misuse the nonprofit's money to benefit yourself or your family or your friends. You don't push for expensive board retreats in the Bahamas when a rented conference room right here in town will do. And if your spouse is the executive director, you don't vote to pay them a salary before the organization can afford one. Um, you would also need to refrain from voting on that salary anyway because you have a conflict of interest if they're your spouse. That's like a whole other topic. But in short, the duty of loyalty says don't do anything that hurts the organization or just helps you. And then that duty of obedience, that third one, the first part of this one is just simple, like don't break the law. Nonprofits have a lot of extra regulations that apply to them. That includes IRS tax regulations, your state's nonprofit laws, all combined on top of just the regular doing business laws. And since you probably don't know what the law is, you need to make sure that you're getting good legal advice and like assessing risk to the organization and following those rules. The second part of the duty of obedience is really don't break your own rules. If you have to follow your bylaws, your policies, your procedures, if I had a nickel for every organization that I helped who didn't follow their own bylaws, I would have a couple $100. Um, but nickels don't go as far as they used to. So we should really like update that expression, I guess. If you have some elaborate nominating committee procedure, let's say, just as an example, let's say you have this elaborate procedure to elect board members, but what really happens is you don't do that. You just find a new board recruit and you like vote them in at your next meeting. You should amend your bylaws because you're not following your own rules and you are violating the duty of obedience. You're not following them and you're supposed to. And the same goes for like your internal controls. If you have a finance process, a conflicts of interest policy, you have to follow them or revise them to be something that you can follow and that's still legal. Um, Finally, and this is kind of like in the vein of like don't break the law, you don't allow the charity's money to be spent improperly. And that just means like you should only be spending the nonprofit's money on mission delivery and mission support or things that support the mission, like back office expenses that are necessary in order to make the mission happen. So let's say the treasurer uses the nonprofit's cash to cover a house payment. Even if they have the full intention of paying back the nonprofit, that is a breach of fiduciary duty. It's also a crime, it's theft, but from this perspective, it is a breach of fiduciary duties. So if you find out that this sort of thing has happened, that there's been some sort of breach of fiduciary duty, and do nothing to fix it, then you have also breached your fiduciary duty. So these are just things that are important, and it's important to know that they exist and it's important to make rules that you can actually follow and to set up systems that support you in upholding your duties because we don't want it to be too hard to run the nonprofit because, frankly, it's already hard enough to run the nonprofit. So let's do a little word problem. Shell Lake Community is a neighborhood association focused on community building. Jeremiah is a new board member, and he learned that the organization is currently the fiscal sponsor for a group called Victory Gardens. After asking some questions, Jeremiah, our new board member, discovers that nobody on the board really knows what Janice and Victory Gardens does or how she spends the grant money that flows through Shell Lake. Janice has a debit card and does the reports to the foundation that provided the grant. The board doesn't use a bookkeeping service and relies on their part-time community coordinator to keep track of the financials for the organization. In fact, Jeremiah, our new board member, works with the staff to learn more about the situation and finds out that Janice and Victory Gardens has applied for several grants that the board never approved of. And it turns out the grant funding was all given up front to the organization as an advance. Unfortunately, because the board didn't realize this was going on, they thought they had plenty of money in the bank to spend on whatever, and some of the foundation grant funding ended up getting spent on an annual neighborhood block party that they host each year and not on what the grant was for. So go ahead and pause this video. Take some time and just write down, based on what we've already learned, what problems do we have here? What are some of the issues that pop up from this? Maybe what fiduciary duties were violated? What do you think? I'll wait. So, for sure, Jeremiah is doing a good job. He's investigating, he's invested, he's trying to execute his duty of due care. He's trying to understand what happened and what the rules are, and he's uncovered a problem. So the first problem is for sure that nobody on the board knows what our fiscally sponsored organization does or how they spend money that we're responsible for. That is definitely a breach of fiduciary duties because you have a duty of due care. So they're not showing up, they're not doing their job, they're not paying attention. And they probably think, well, they've delegated that to staff, so they don't have to pay attention. But as we've already talked about, that is not correct. Another issue that I'm seeing, something we haven't really talked about, is that they gave their fiscally sponsored organization, Janice, a debit card. And she just gets to like spend money without anybody's oversight or approval. Now, what we know from what we've learned is that the board ultimately is responsible for all financial transactions. And so this doesn't seem like a very good system for them to stay informed about what's happening. Also, it says they are not using a bookkeeping service. So they're just like relying on a part-time staff person to like try and do the accounting. So here again, you see like they've delegated away some stuff in a way that violates their fiduciary duties. They're not really taking good care. What do we think Jeremiah should do in this situation? Because this is like a real tough situation for a new board member to be in, because he's sort of had no input into any of this. I would say Jeremiah should write up his findings and put it on the agenda for the next board meeting and probably come up with a solution for how they can get money back into the account to make up for the money that they spent that they shouldn't have spent. And he probably has an obligation to bring this to the full board's attention. And I would say, from a management perspective, Jeremiah should come prepared with a plan of action or some suggestions for how the organization should fix this. And then the real question is, what happens if the board doesn't want to fix it? That's when Jeremiah should probably quit. But right now, he is a board member and he has fiduciary duties. And so he really needs to bring this up, and everyone needs to be advised of this circumstance. And hopefully, this board can figure out what to do. And that probably looks like talking to someone like me for some advice. So, using that example, how do we delegate the authority becomes sort of important, because what we saw with the Shell Lake example is they didn't really have policies in place. They didn't really give their staff a clear picture on what they should be doing. And so that's why some of those things got out of hand, right? So, how should we delegate authority to our team? We should adopt policies and procedures. We can delegate our authority through a resolution that maybe gives someone a temporary responsibility or a continuing responsibility. We delegate our authority as a board through creating the executive director's job description. And it's important to just sort of note that, like, some delegation is ongoing and some is very temporary. So, what are some of those things, those policies that we should be adopting that Shell Lake probably should have had? So, they need to make policies around how to maintain records of the decisions that the board made. Where do we keep our meeting minutes? How do we store our information? How do we go back and look at what we decided? They need to have policies around internal financial controls. We have to have policies around conflicts of interest. It's also great to have policies around how do we manage disagreements? Um, Things like non discrimination, equal opportunity. What is our gift acceptance policy? What are our policies around our staff, our employees, contractors, volunteers? Like, how do we manage all of those human resources that we interact with? And then any other policy that is just reasonable or necessary for our organization. All right, so let's switch gears a little bit and talk about voting member organizations. So we need to remember there are some wrinkles that go along with voting member organizations. There's some things that we need to know about voting member organizations, and the primary one is just that any organization that has voting members, the voting members have legal rights. And that just adds a wrinkle to the way that we govern ourselves. And it adds a few policies to my list on the previous slide, like member grievances. So you want to be aware if you're going to work with an organization, whether you're a board member or like helping them in a volunteer lawyer capacity, you need to be aware of what the state statute gives to voting members. And then you need to know if your organization has drafted those rights away. So let me give you an example. In Minnesota, voting member organizations, the members have a right to an annual meeting every year, which in which the board reports on the activities of the organization and the financial activity. That is the default provision, but you can draft that away by putting it in your bylaws that you don't have it. The state of Minnesota gives voting members the right to vote on who the directors are, who the board is, unless the articles or bylaws say something different. So you need to both be aware of like what the law says and then also what your documents say and whether they're using the default provision. If it's silent, then the statute controls. If we've drafted it away, then our document says something else. Many organizations will create member rights that are not given in the statute. They will create all sorts of like things that the voting members have the right to vote on, like if the board is going to spend more than $10,000, the members have a right to vote on it. Ain't no statute creating that rule, okay? They just did that to themselves. So it's important for you to be aware that that is something like your organization did to itself and it's not actually legally required. Another one is in Minnesota, the statute gives members the right to amend the articles of incorporation unless your articles and bylaws say something different. Um, Most of the time, I don't think that members need to be able to vote on articles or bylaws in general. Um, that's a whole other topic, but I like to draft these things away to the greatest extent possible because it just creates bureaucracy. And there should be good transparency and accountability at the board level where we're communicating to our community, and we should be able to trust those folks. So, other issues that can come up, um, voting member organizations have these requirements around like what is the date that you are a valid member for the purpose of voting, and it's called a record date. And basically it's like if we're going to have a meeting of the members where the members are going to vote, what what day do you have to be a member by in order to show up and vote at the meeting? This can be something that like gets really dramatic when there is a voting member population that is trying to vote for or against something, and they're trying to like coalesce a group around this issue, and people will try and manipulate the record date to either have fewer or more people in the room for that vote. So it's just something that you want to pay attention to if you're working with a voting member organization. Okay, so I've mentioned the bylaws like 100 times, so we might as well talk about them. So the very top level of governance above policy and procedure is the organization's bylaws. Sometimes an organization will call it a constitution, especially churches, they like to call it a constitution. but I'm just going to call it bylaws. The real like nuts and bolts of corporate governance are handled in the nonprofit corporation's bylaws. This is somewhat akin to like a member control agreement for an LLC if you have a business background. But again, there are no owners. So it's really just like, how do we have meetings? How do we add people to the board? How do we like remove people from the board? Um, this is really like that top level. And it's very important that if you're going to work with an organization, either as a board volunteer or as their lawyer, you want to look through the bylaws before you give them any advice, because this is the document that like really tells you what their own rules are. Yes, the statute applies, but so many things in the statute are like, it's this unless the bylaws say something else. So you need to look at the bylaws. I really um, don't like giving advice to a client if they haven't been able to provide a copy of their bylaws, because it's like, well, it depends what your bylaws say about how this would happen. So you really want to look at those before you give too much advice, especially about hot button things like removal of board members or stuff like that. These are just like, they're rules that you have to either live with or you have to change once you find out how bad they are. And wouldn't it be easier to deal with this situation if we amended our bylaws? Um, so many organizations really struggle with having bylaws that are onerous and terrible, or like they don't fit, or somebody tried to act like a lawyer and they're unintelligible because they're just full of a bunch of jargon, or they've just like got so many internal references that they're impossible. So I'm a big fan of updating and simplifying while still addressing all of the topics that we need to address in order to not have to go look at the statute all the time. So just to recap, you want to read those bylaws because these are the rules, except when they haven't talked about it and you have to check the statute anyway. So, what is my sort of like first look checklist? If it's the first time you're opening up the document, you're working with the organization, you're volunteering for the organization, you want to like keep these things in mind. So, here's my checklist. First, just review the document and like notice if there's any sort of like conflicting terms with the articles. Like, do the articles say they have voting members, but the bylaws like don't mention it? Or do the articles like say their purpose statement, but then their bylaws like have some radically different thing that they've changed over the years? Does their bylaws say that like they can use written action and decide things between meetings, but they didn't opt in the articles? Those are sort of like just looking for those conflicting points is number one. Many nonprofits change their bylaws without realizing they should be updating the articles. And many organizations put terms from the articles in the bylaws, which makes no sense to me because that's not where you change those terms. It has to live in the articles. So, like, just don't put them in the bylaws at all. All right, number two, again, just like, what is the age or the health of this document? Like, when was the last time this was updated? If it was like done on a typewriter and you're looking at like some ancient mimeograph, like, time to update. Does the nonprofit like still follow the process that's outlined in this document, or have they like changed things and you know that, or you should ask them? If things sound like really weird and don't make sense, they probably don't do it anymore. Number three, look at any membership terms. Just like if there's any member terms at all, you need to look at those because it's going to come up. And then number four, look at the board sections. Like, read that. Make sure you understand the provisions in the sections that govern the board. Overall, number five, just check to see if the bylaws are difficult to follow. If they're not tied to reality based on how we actually do things, or like, are they too short? Are they like totally silent on lots of stuff and you're going to have to be looking at the statute all the time? That makes them really hard to follow because you're never really just following them. You're constantly looking at the statute at the same time. And then number 6, like just overall check for like lack of usability because a lawyer or a wannabe lawyer drafted them into oblivion and everything is unintelligible garbage like shall heretofore party of the first part shall forbear from. All of that stuff is unintelligible gibberish to everyone. So don't. And if it's full of that, we need to start over. Um, use of just like jargony things, acronyms, double numbers, like the word one with one in parentheses. That is just like a recipe for mistakes to be made. So just check for that. And then number 7, always check the statute. If there are things that are missing, then you have to remember the statutory default applies in that case. Many nonprofit boards do not know this, do not remember this, or they have like terrible bylaws and they want the statute to apply, but somebody in the past made it weird and they wish that the statute applied, but it doesn't. So you got to double check against the statute. And then number 8, if the nonprofit is not from your home state, so like I'm in Minnesota, if the nonprofit is actually registered it was born in Vermont and registered to do business in Minnesota as a foreign entity, remember that you need to check the other state's statute because that is the statute that's applying. The big one that I see with this a lot is like Delaware. Everybody loves to like form things in Delaware, and Delaware has like an absolutely not great nonprofit statute. I'm not going to say it's total garbage because there are worse places, but like it's pretty bad. It's just business law with a couple of provisions and then you have to refer to the business sections. It's horrible. Anyway, so now that we've kind of talked about like you know what to look for in the articles, you know what to look for in the bylaws, like we should talk about enforcement. So one thing you need to remember is just that IRS tax exemption is a privilege, not a right. Nonprofits are not born with IRS tax exemption. You must apply for it. It's something that can be lost if your organization is not careful. There are 6 key areas to stay on the IRS's good side and to keep that income tax exemption. And the IRS is the primary enforcement agency. It's the federal level enforcement agency. So there are some things that they really care about that really tick them off. And those are things like private benefit and private inurement. Okay, we would more likely know those terms as like insider dealing, right? When you're using the nonprofit's resources for yourself or to like line your own pockets. They really have a beef with unrelated business income. Nonprofits are not allowed to just like start a car wash business and compete with other businesses and then collect money and not pay income tax. If your business is not related to your charitable purpose, you have to pay income tax, and the IRS is sensitive to this and will expect you to pay it. Also, like you have an obligation to just annually report to the IRS. That is done through the Form 990. And while we don't pay tax, we still need to file this information return every year. And if you don't do it for 2 years, that's fine. But the third year you don't file your 990, you're going to get revoked. And they're like, hey, we gave you this privilege. All we said was you got to follow our 8,000 rules and to file this form every year. You didn't file the form 3 years in a row, so now you're done. And they put you in a timeout chair and you have to reapply. And it's just mechanical. If you don't file it in the third year, the computer just revokes you. There's no human being involved. It just happens. So you have to make sure that you file at least once every 3 years. Also, lobbying. A lot of people think like, oh, nonprofits can't do any lobbying. Well, you can do a little bit of lobbying. but no substantial part of your operation can be lobbying. Well, what is substantial? Well, that's like a whole other continuing ed thing. But you can do a little bit of lobbying, but if you do too much lobbying, the IRS is going to be mad and they're going to take away your tax exemption. Also, like political campaign activity, you cannot do any of that. No, no, no. No endorsing candidates, none of that. You can't be doing any of that. The IRS gets mad if you do that. And then just like you have to operate primarily for your stated exempt purpose. The IRS is like, look, we gave you income tax exemption, okay? And that was on the basis of like you primarily exist to do this good thing. So that's fine as long as you, for the most part, are always doing that good thing. If you start doing too much other stuff, why should you have tax exemption? That's basically their outlook. So you just need to remember that those are kind of like the 6 big areas, and then there's like 8,000 little rules that all feed into all those things. But those are the big ones. Anytime you're dealing with anything in those 6 areas, it's important to pay attention to the details. I do have like a primer available online. You can just go to this link, birkenlaw.com/6ways. That's birkenlaw.com/6, WAYS, and download the primer on 6 ways to lose your tax exemption. It's just kind of a good cheat sheet if you're just getting started in this area. All right, so that was a lot of content, and you may just be like overwhelmed and terrified. So, for the board member lawyers watching this, I'm just here to say look, nonprofits do need legal advice. They are businesses with an extra twist. They do need you. I can't help all of them. I am trying. I've got DIY tools now, but like you're still going to be called upon to help. So, don't be terrified. Just be safe. If you're on the board, just be sure to um, check out my other CLEs on board service, which is really helpful. And just put it on the record. Like, what is your role with this board? Are you actually on the board? Then be on the board and let them know that you're not their lawyer. If you're willing to be their lawyer, like tell them how much. I actually put together a little like a template draft letter that you can, download. It's a Word document, it's fully editable. You can just grab that and like in a nice way without being like, I'm not your lawyer, ethics, blah. You can communicate that you're excited to help them and that you have some limitations, that you want to make sure that they understand that you're a family law attorney and you're not a nonprofit law expert, and that you will be there to exercise your good business judgment and that you will help them with legal issues that you feel competent in, but that you may from time to time need to refer them to expert counsel. That's a totally reasonable thing to do. So if you would like a little start on a letter like that, just go to birkenlaw.com/board-service and download the template. It's easy, and I think it just goes a long way in helping set expectations. So I hope this was helpful. I know we covered a lot of ground. Feel free to reach out to me anytime. I'm on Twitter/X at Jess Birken. You can find me at birkenlaw.com. You can find me at hackyourpractice.lawyer. I'm always happy to talk to colleagues and help folks get acclimated, or like if you have a referral for me, that would be amazing. So just feel free to reach out anytime. Okay, thanks, y'all.